Well, it's the witching hour, and or the bewitching hour, and I expect with the weather today that there will be some other folks straggling in. I hope so. So let's get started. Good afternoon. My name is John Ellingson. I have the pleasure of moderating this panel discussion that explores the meaning of human dignity in our Montana Constitution. Montana is often described as being high, wide, and handsome, and I think all of us would agree with that. But I'm sure that this phrase is usually used to describe our magnificent landscape. I would suggest that it could also be used to describe the magnificent feature of our political landscape, which is our Montana Constitution. And tucked away in the beautiful Declaration of Rights of our Constitution is a gem. The assertion that, quote, the dignity of the human being is inviolable. But what does this mean? What kind of life would each of us lead if our human dignity was fully respected? As I prepared for the Molly course, which led to this panel, I found this description. A person would have, quote, the freedom to write her life story. It is her free will, it is her autonomy and her freedom to shape her life and fulfill herself according to her own will, rather than the will of others or the dictates of external circumstances. Today, we are privileged to have a distinguished panel to help us think about this important concept, and isn't it timely that we think about this issue at this time when the dignity of so many marginalized individuals throughout the world is being challenged in so many different arenas. And so I'm hoping to learn what this can mean to us here in Montana. Our panelists consist of Caitlin Borgman, who is the Executive Director of the Montana affiliate of the American Civil Liberties Union, Professor Anthony Johnstone, the Constitutional Law Professor here at the university, and former Supreme Court Justice James Nelson. And there are not many who would argue with me when I describe him as the most learned of the Supreme Court justices that we have ever had here in Montana. Well, listen to what he has to say, and I'll bet you'll agree with me. He first applied the dignity clause to the Walker case, and he urged its broader use in subsequent compelling concurring opinions. So I am excited to hear what these panelists will have to say. I want to give appreciation to the Molly program at the university, which accepted my class proposal, and also to Anthony Johnstone and the law school and the other folks who put together, who made this possible to be hosted here at the law school, and who also facilitated getting MCAT to record it and VisionNet so that we could hear Justice Nelson from Helena and he wouldn't have to brave the roads today to come over to address us. I suggest that each of the panelists take 15 to 20 minutes, leaving time at the end for questions, and I suggest that we proceed in the order of Justice Nelson first, Anthony Johnstone second, and Caitlin Borgman third. So, Justice Nelson, if you would.
Thank you, Dylan, for that very long introduction. No pressure on me, I can say. And my apologies for not being there in person, but as John said, the roads are just terrible, and I didn't want to drive on title of this symposium or seminar, whatever we want to call it, as I understand it, is human dignity and the Montana Constitution meeting important for future Supreme Court decisions, which is an imposing title, I think. And I'd like to leave you with a couple of thoughts in the time I have. And I'd like to start by taking just a few minutes to mention something which I think you all are going to believe is off topic. But I would ask that you just bear with me and I'll tie it all up together at the end of my remarks. You that have studied the Constitution, and I believe most of you have, and the federal Constitution, you know that the federal Constitution textually protects only human rights. There are no rights in the Constitution protecting any non-human legal entity, such as a corporation or partnership or an LLC or an association. So the Constitution protects only human rights. Yet you also know that the Supreme Court of the United States has created, from those human rights and from the text of the Constitution, rights for corporations and non-human legal entities. And I want to refer you to a book. I urge you all to read it. It's called We Corporations: How American Businesses Won Their Civil Rights. It's written by Professor Adam Winkler, who's a law professor at UCLA. And it is one of the most interesting books I've ever read, because it talks in terms not of just how various rights in the corporation or in the Constitution were created by the Supreme Court for corporations and non-human legal entities, but it talks about that in the context of what's going on at the time in terms of history, society, economics, and so forth. It truly is a fascinating book. I only mention this from the standpoint that there's, when I finished it, there's an overall large takeaway that I gained from reading this book. And it's 2 points. First of all, the people that argued for corporate rights, for the creation of corporate rights, were good attorneys, and they were attorneys with a particular vision of the federal Constitution and how that vision would help their clients. So there's the first big takeaway: attorneys with vision. And the second big takeaway is that the Supreme Court took the risk of implementing those various visions and creating, essentially from whole cloth, corporate rights for non-human legal entities. So, we have attorneys with vision and courts willing to take a risk. And you put those two things together, and over the period of history, on various theories that the Supreme Court articulates and are discussed in Winkler's book, over the course of history, the Supreme Court has created a whole series of constitutional rights for corporations and non-human legal entities. And it's fascinating how they did that. So keep those two words in mind: vision and risk. Moving along, after I retired in 2013, and about a year after that, I was asked to speak to a group of political science students at Montana State University. And I was very happy to do so. Serendipitously, at about the same time, I was asked by the Compassion and Choices Montana organization, which is the organization in Montana that is really supportive and is kind of promoter of physician-assisted dying and medical assistance in dying. In any event, they were putting out a publication called 5 Years of Dignity, the Baxter Ruling, and End of Life Freedom in Montana. And they asked me to write a short piece for that publication. And I was glad to do that also. What I'd like to do now, again, if you'll bear with me, I'd like to read that piece I wrote because I think it encapsulates a lot of my thinking on the right to human dignity, its importance, its place in the Constitution, well, let me just read it and you make up your own mind. I was speaking to a group of students recently, and I was asked if there were any decisions during my career as a Supreme Court Justice that I regretted. I answered that I could think of a couple, and that Baxter was one of two. I explained that appellate courts typically decide cases on the narrowest grounds, avoiding constitutional issues if possible. And that, of course, is what the Montana Supreme Court did in Baxter. The court concluded that reading various Montana statutes together, persons with incurable illnesses who were going to die within a short period of time, accompanied by great suffering, had a legal avenue to seek and receive their physician's assistance in dying a dignified death. And despite its detractors, we know that over the intervening 5 years since Baxter, Montanans suffering those types of illnesses has successfully sought and obtained that assistance from various compassionate physicians in the state. Baxter has worked successfully and as intended, and without the parade of horribles predicted by those who would interfere with the patient's most personal decision. So what's my regret? District Judge Dorothy McCarter had written a courageous and brilliant decision in the underlying case. She concluded that Montana's constitutional rights of individual privacy and dignity protected the right of incurably ill patients to end their physical and mental suffering with the assistance of their physicians. The court didn't disagree with her, but as noted, simply concluded that there was a narrower way to uphold her decision on non-constitutional grounds. And that's what I regret. As I argued at some length in my special concurrence, I believed, and I still categorically believe, that our court should have simply upheld Judge McCarter's decision on the constitutional basis she determined. It wasn't that the Supreme Court was wrong, it was simply that Judge McCarter was right. Indeed, more right. Men and women who are enduring the maelstrom of a life-ending illness, who are suffering terribly from pain and disability, who are not only losing their bodies to their illness, but, and in many cases worse, their spirits, their dignity, and their autonomy, cultivated and treasured over a lifetime, do, and I repeat, do have an individual constitutional right to end their lives with the assistance of their physicians. That right is protected, guaranteed by Montana's Constitution. That right is fundamental. It is a natural right, grounded in the attributes of humanness with which each of us is born. It is a right grounded in our ability to make and take responsibility for our own moral decisions. It is an elemental part of our individual sentience and consciousness. It is a right that society must respect. My regret, then, lies in our court's failure to recognize and apply these incredibly powerful rights and attributes of humanity. I can think of no more empowering and comforting final thought in the mind of a person who chooses to end her own life and personal suffering than the knowledge that her autonomy, privacy, dignity were respected by her family, friends, and fellow citizens to the end. She was born a whole person, and she died the same way. She was loved. Risk is a part of life. Some accept, even seek, more risk than others. But we all live out our lives with risks, great and small. That also is a part of the human condition. I believe, too, that courts deciding cases like Baxter should be willing to take risks. I believe that sometimes the road not taken is the better. I believe that upholding fundamental constitutional rights is often better than searching for and creating a narrower path. I believe that is what the Constitution is for, to protect the most sacred and fundamental natural rights that we as human beings possess. The right of inviolable human dignity, the right of individual privacy, the right of autonomy to find our own path through life and into death. The playwright Neil Simon once observed, "If no one ever took risks, Michelangelo would have painted the Sistine floor." And that's my regret. Our court painted the floor when we should have painted the ceiling. And in closing, I'd like to say this also. For you Molly students, I applaud your commitment to understanding our Constitution, to finding out what it means and what it says, and to supporting it. And I would venture to say, without fear of too much contradiction, then after Professor Ellingson's class, you probably know more about the Constitution of Montana than 95% of your fellow citizens, and probably 90% of the people sitting in Helena right now making laws. They clearly don't violate the Constitution. So I applaud your commitment and your efforts, and I urge you to keep doing what you're doing. To the law students in the class, and I can't see any of you because I'm simply looking at the camera, but to the law students, I'd like to leave you with this thought. As you become lawyers and go out into the practice of law, form your own vision of what Montana's Constitution means to your clients. And when you become legislators, as I know some of you will, keep that vision at the forefront when you're participating in making laws for the state of Montana. Keep that vision operative in your mind always. And when some of you become district judges, as I expect that some of you will, as a judge, take the risk of implementing that vision and the vision of your fellow citizens of the Constitution. Take the risk of implementing that decision in your decision-making process as a trial judge. And for those of you who I hope very sincerely will become Supreme Court justices in Montana, I would also urge you to keep your vision forefront and make that a part of your decision-making process. And in closing, to all of you, I would urge that you paint the ceiling with the Constitution and not the floor. Thank you.
Thank you, Justice Nelson. Professor Johnstone.
I should have paid closer attention to the emails that had me following Justice Nelson. Thanks, John. It's such a pleasure to be here among so many friends. The great thing about lawyers is you say you practice with them even when you were litigating against them. And my friend Mark Connell, who with me litigated the Baxter case, I did not win Justice Nelson's vote on that case. Mark did and elaborated that. a vision that took root in Justice Nelson's remarkable opinion in that, as well as the other cases that you've studied. John and I, of course, have litigated together for the state for a long time. And it's great to share this with a scholar like Caitlin, who is, for all of Montana's benefit, putting her work now behind the ACLU and doing such great work there. I also want to acknowledge Bob Campbell, delegate of the Constitutional Convention, who has come to join us. And Bob is such a great friend of the law school and all of the Montana constitutional work we do here. I'm glad that Justice Nelson talked about students having their own vision. I know that my students, when I'm teaching Montana constitutional law right now, tomorrow we will begin studying human dignity, and I keep telling them, there's not an exam in this class. I wouldn't dare to give you a multiple choice exam on something so deep, so rich, so promising as the Montana Constitution. I'm just giving you the tools to go out and develop your own vision and strike that. I think that at the moment is really unsatisfying to the students in the class who want to have the right answers and grappling with these difficult questions, but I hope they understand. I think Justice Nelson is helping them understand how important it is that what we're doing there is helping shape your vision, because your vision is going to be Montana's vision of this remarkable document. So I'm going to, I guess, do the job of the law professor in terms of just providing some background and context, some of which may already be familiar to those of you in the Molly course, that helps unpack this. I think it's a puzzle of dignity in the Constitution, dignity as a legal concept, and I provided a little bit of background in a handout. We see it invoked so often in ordinary discussion and legal decisions. We've seen it in Montana law emerge in cases ranging from the treatment of prisoners, the right of counsel in civil commitment proceedings, the right to physician aid in dying. We've seen it often in Justice Nelson's opinions, as elaboration of it across the range of human rights, the gay rights cases, the medical marijuana cases even. We've seen them come up. The trick for lawyers and judges is to try to, if you have a vision, is how you translate that into law. And so the way that we usually try to do that is by putting this idea of dignity in some context, just as it's put in context in Section 4 itself. And so much of it's hard for any of us to do work here without a debt to the famous, to my view, Tom Huff and Matthew Clifford's piece on dignity in the Montana Constitution, which is just a great starting point for all of this. So I think one of the things that makes dignity puzzling, and this just actually occurred to me right now, so I'll probably have to write it down and teach more about it at some point, is that it's not clear from its statement in Section 4, which I hope you've noticed. I've convinced the dean to start writing the Montana Constitution on the walls around the law school. So I hope you're noticing that in nice copper gilt. I think it's just paint, but we'll pretend that it's copper. Dignity, it's not necessarily expressed as a right. It is in the Declaration of Rights. But I think one of the puzzles here is that if you put it in the context of our American constitutional political morality, as Ronald Dworkin might call it, it might serve better as a premise rather than a right, a premise from which human rights follow, human rights to life, liberty, and property, for example, follow, and then from there, from which enumerated rights, enumerated throughout the Article 2 of the Montana Constitution, as elaborated by our courts, really do the work as law. And so that might be a starting point, is to think about dignity. It's possible, at least, if we wonder why dignity hasn't done more work than it has done, and notwithstanding Justice Nelson's bold elaboration of it, is that it might be a premise rather than a right in our tradition, including in Montana. So To start out, to frame it up, Section 4 is a innovation in the Montana Constitution. It was new to the 1972 Constitution. Like most constitutions adopted in the late 19th century, Montana's did not provide for equal protection. Wyoming's did, and they got a motto, the equality state, and that was important, but most state constitutions didn't provide for that. It was an innovation that had developed and really was most famous in the 14th Amendment of 1868, the Federal Equal Protection Clause. But by 1972, you have the 14th Amendment on the books. You have other states beginning to add equality guarantees to their constitution. You have the model of the 1964 Civil Rights Act, and what you see there is an impetus to include equality guarantees in Montana. And at the core, we might think of that is a premise that dignity is the quality of being worthy of respect. And there's no doubt, as we think more about the context, that the idea of human dignity in all of its richness was in the air. It was studied by the delegates at the time. If we look at then the structure of Section 2, we see, and this borrows, this is something that Huff and Clifford did such a nice job with. It's three sentences running from the more general to more specific. And I should say that Huff and Clifford do think that dignity is a right. And again, I'm not so sure. I'm not sure that it's not a right, but I think it also might be a premise as an easier way to understand it. You start with the idea, if you want to start at the end, we have the very specific Title VII of Civil Rights Act type language of non-discrimination. It's for broadest applicability, it applies to public and private discrimination, and it expands into all sorts of classes, all sorts of really innovative classes. I actually think, as I'll conclude in terms of work going forward, I think there's a lot of fruitful work to be done in thinking about what Montanans meant by things like, we know race, color, sex, political, religious ideas. What do we mean by culture? What do we mean by social origin or condition? How might that impact certain current debates we're having? I think one of the things I challenge my students to do is think about, well, gosh, does social origin or condition, does that suggest something about alienage or status in terms of immigration debates, etc. Those sorts of things. But that's not the subject of today's work. But don't ignore it. I think that there clearly is, there's a lot of work to be done, and that is quite a bit more tractable to lawyers, that last sentence, than the first sentence. The sentence in the middle is that equal protection guarantee to provide kind of a general scoop up incorporation, upside down incorporation of federal guarantee outside of the protected classes listed in the third sentence. And then we end at the beginning this idea of dignity. It's a narrower scope. It is not any person, and we, whether we like it or not, corporations are at least associations of persons who have rights, if not persons themselves. So dignity is both a broader principle, but it has a narrower application. Presumably, if it is a right, there's nothing here suggesting that it's a right that would apply to relationships among private individuals, among citizens, unlike the very ambitious and important final sentence there that does apply to private discrimination, is implemented mostly through our State Human Rights Act. But we don't have much more to go on about just how that fits in that paragraph, that first sentence. So we can look to history, and this is one of the remarkable things in Rick Applegate's amazing studies. I sometimes think I should just copy that and assign that to my students for reading here. He had prepared the delegates with a very deep, rich understanding of dignity, as you've been exploring in John's class. It even includes, right? He cites Kant. They have Kant there, right in the original introduction to why we have rights, and they discuss this distinction between having value and worth. Worth being dignity, that it's something inherent to us. It's not something that depends on someone else, which is, as Huff and Clifford explain, as John situated in your class, I believe, is a Enlightenment humanization of traditional theology in terms of it. Right? That the dignity is within ourselves. Previously, we were dignified by being made in God's image. Post the Enlightenment, the idea that's in the Montana Constitution is that that dignity is inherent. So that's the background, and they absolutely knew what they were doing when they were using that word with respect to the idea that they were drawing on. But we have to figure out, okay, well, now what work does it do as a right, if it is a right? It's got that word inviolable, and as Justice Nelson has pointed out, it just means it's something you just can't violate. Well, that would be a strange, there are all sorts of indignities that we suffer at each other's hands and at the state's hands, ranging from the sublime to the ridiculous, ranging from cases such as Walker and Baxter to having to wait too long at the DMV. Right? I mean, so how do we begin to grasp this idea that it's inviolable? And I guess what I'd suggest is what the delegates are drawing on there against the backdrop of the Applegate study is explicitly a natural right, a human rights tradition. We see it echoed in Section 3, which talks about inalienable rights. And as Jeremy Bentham understood in 1776, when Thomas Jefferson and the Virginia delegates were making their original attempts at this American view of inalienable rights, that doesn't tell you much in terms of the law. It tells you a source of law, that these rights are inalienable, because of course we alienate these rights. Of course we give up life, liberty, and property at times to enter into society. That is the point. That is our American and our Western natural rights tradition. That goes back to Locke. That's part of the deal. We give up those rights, but the reason we remind our government of this in the Declaration of Independence and in Montana's Constitution, that there are inviolable and inalienable rights, is to suggest that is the deal, remind them of the deal, and that if they are to act upon our lives, liberty, or property, for example, that it must be justified with regard to those terms of the deal. In other words, government, if you're going to abridge my life, liberty, or property, you're going to do it so as to further our collective lives, liberty, or property. Right? So I can have property in a state of nature, but it doesn't do me much good without laws. But if you tax us, take some of my property to hire a police officer or to set up a court to adjudicate that, then I actually have a more meaningful sort of property. And I think when we see those terms inalienable and inviolable, that's what they're talking about. I'm not sure. Maybe that's not what Thomas Jefferson meant. Maybe we have an absolute right against government at times. We certainly do. We do that, and this is handled in Sections 1 and 2 of the Declaration of Rights. We can revolt against our government and throw it out. I think certainly you do. It is inviolable and inalienable to that amount. If you think government's not upholding its term of the deal, you can get a new government. But beyond that, it's harder to put in the frame of reference as the rights that begin to occur right after the dignity clause. And again, it's not absolutely clear that's where the context leads, but I think that's one of the ways we might try to understand dignity as a premise. Of course, one of the fascinating things, Section 4 is the most cosmopolitan piece of the Montana Constitution. It was borrowed from, based on the Puerto Rican Constitution, based earlier on the German Constitution, and this idea of autonomy. But again, that might be a premise that then is going to be, as James Madison said, be liquidated, be cashed out in different ways based on different political moralities, based on different systems, different traditions of rights. And one way we might know that is by, for example, looking at the different direction. The easiest example is the European example, right? So Germans have a right to human dignity. That is against a very different backdrop that, fortunately, we do not have historically in the United States in quite the same way. We have our own genocides, but we don't have the German genocide example, and that clearly motivated in terms of time and place. So, not surprising to see that you would reach a different reading of dignity, and so that in Germany, German constitutional law is different in terms of exactly how they approach the ideas of rights. The continental tradition is a little different in terms of it. But in Germany, they say that the protection of the unborn is a command, not a absolute command, not a categorical command, but is something that is suggested, right? Dignity is on the other side of the abortion debate as a legal concept than it is in Montana, for example, where it's, in the Armstrong case, dignity is on the side of the woman's autonomy as opposed to the unborn being's autonomy. So that just gives you, you can look at it, but if you don't see how it fits into this broader context, it can be confusing. There's interesting cases dealing with laser tag and some other areas there. So what do we do with that? If we're not sure that dignity is a standalone right, if it might be a premise, what other work can it do? Yes, it is. I think there's agreement that the delegates understand it, that we should understand it as honoring the worth of autonomous individuals. Absolutely. But where does that get you in law? It's a pretty thin conception of dignity. Now, you can bring your vision to it as a judge, and we should all be so lucky that we would have more judges who have Justice Nelson's vision. It's just not clear that that's the vision that is expressed in the Montana Constitution. And so we see this we're kind of stuck. Dignity's kind of stuck. After Justice Nelson has left, we haven't seen dignity doing a ton of work, really, on the court, in the courts anywhere. We haven't seen lawyers bringing forward the claims. Maybe, I hope some of you will. I'll be watching as students. One way we might break that logjam is, as I said, keep reading. Move on to the following sentences. Understand that dignity is about as powerful a premise for human equality as you can come up with. And that even if it's a premise, it is a very strong injunction to all of us, including the state and private individuals, as expressed by Section 4 itself, to treat each other equally because of dignity. Dignity doesn't do that work on its own, but what it does is it accelerates, it amplifies these principles of equality that are in our Constitution and are even less explored than dignity. You can go through, you will find dignity mentioned infinitely more times, as far as I can tell, than, for example, the idea of social origin or condition or cultural discrimination. I would suggest that if you want dignity to do some work, have it do that work as a premise for Montana's truly unique and far more legally tractable anti-discrimination provisions, which may not draw as many people to a classroom, but I think are much more likely to be result in practical elaboration of that dignity premise in Montana. So.
Thank you.
Yep.
Professor.
Thanks, Jim.
So that was actually a really good segue to the
So what
topic
next?
that I'm going to be talking about. But first of all, I just wanted to thank John for organizing this panel and for the opportunity to participate. I wish I could have sat in on his Molly class. And I did publish an article in the Montana Law Review on the topic that I'm about to talk about in 2017, I think it was, and did a Constitution Day lecture, and very much benefited from conversations with Justice Nelson and Anthony on the topic that I'm going to address. So I am actually going to be focusing on the way in which the Dignity Clause in the Montana Constitution interacts with the Equal Protection Clause in the Montana Constitution, which is the thing that Anthony was just talking about. I do want to say that I think, as Anthony has mentioned, there have been really strong arguments made for an individual, for a freestanding right to dignity under the Montana Constitution. Justice Nelson talked about it and has eloquently written about it in many of his opinions. And as Anthony mentioned, Tom Huff and Matthew Clifford have also made a really strong argument about that in their article about the Dignity Clause. but I'm going to be focusing on the Equal Protection Clause. So you have here a nice kind of list of some of the international opinions, but also Montana opinions in which the Dignity Clause was considered or played a role in the decisions. What's interesting is that even though the Dignity Clause is in Section 4 and is followed by the Equal Protection Clause and then the more specific Non-Discrimination Clause, the Montana Supreme Court has not applied the Dignity Clause in the equal protection context. And I want to talk about it specifically in the context of discrimination against transgender and non-binary individuals. But you could apply it in other contexts too, some of which I'll reference. So just by way of background for people who aren't familiar, a transgender person is a person whose gender identity does not correspond with the sex that that person was assigned at birth. A non-binary person is someone whose gender identity does not correspond with either male or female. Gender identity is different from sexual orientation. So sexual orientation is a person's enduring physical, romantic attraction to another person, straight, gay, lesbian, bisexual. Gender identity is a person's internal, personal sense of being a man, a woman, or outside of the gender binary. Discrimination against transgender and non-binary people has been prominent in the news in the last several years, where we have seen what I'll refer to as bathroom panic legislation most prominently, which is legislation that tries to prevent transgender and non-binary people from using a bathroom that does not correspond with the sex that they were assigned at birth. And there was actually a measure in Montana in the 2017 legislative session that was defeated in committee. It did not get voted out of committee. That was going to be a sort of similar provision that applied to locker rooms and bathrooms and any place where a person may be in a state of undress. And there was also a measure that the Montana Family Foundation was collecting signatures for to put on the ballot last year, and that did not collect sufficient signatures to make it onto the ballot. So I'm not going to say a whole lot more. I'm just trying to keep these remarks a little bit shorter about transgender discrimination. Suffice it to say, it's extremely harmful to individuals who identify as transgender or non-binary. There has been a horrific amount of violence against these individuals, especially, but not exclusively, trans women of color. They suffer high rates of all kinds of social stressors, including transphobia, family rejection, lack of social support, discrimination, which I'm going to be focusing on. One of the things that, turning specifically to bathroom panic legislation, that's really interesting is that it's not new at all. So the idea of banishing people from bathrooms, people who have marginalized identities, goes back to, for example, the Jim Crow era, where there was concern that racially integrated public bathrooms would be problematic. There was also panic stoked about bathrooms during debates about the Equal Rights Amendment, and the idea that we would now suddenly have to have unisex bathrooms if we pass the ERA. So, as one commentator has put it, for more than 100 years, Americans have projected their most profound fears about social change onto public restrooms. So, you know, so the ACLU has fought against the legislation in the Montana legislature, and then also against it being put onto the ballot. And sometimes when I would talk to ACLU supporters, people would say, well, this is just such a trivial issue. Why are we talking about bathrooms? And so I just want to mention this history very briefly to say it's not trivial at all. Because if a person can't access a public restroom, then they can't attend any number of public lands, public facilities, libraries, parks, places where they would be forced to choose a bathroom, either a bathroom that was perhaps dangerous for them to use because they appear and present as male but are being forced now to use a female women's restroom, or they just feel uncomfortable choosing, the wrong bathroom for their gender identity, and so they're essentially prohibited from fully participating in public life through these measures. So, in terms of a legal analysis, like I said, the Montana Supreme Court has not addressed, the Supreme Court has not addressed the issue of transgender discrimination, but it also has not addressed how the Dignity Clause might inform the Equal Protection Clause in the Montana Constitution. So like Anthony said, regardless of how you feel about whether there's a freestanding right to dignity under the Constitution, it seems pretty clear that at minimum it should be read to inform the clauses that follow it in the very same section, which are the Equal Protection Clause and then the specific non-discrimination clause. But that hasn't happened so far. So, for example, speaking of missed opportunities, when Justice Nelson was talking about what he saw as a missed opportunity in Baxter, in Snetzinger versus Montana University System in 2004, the Montana Supreme Court addressed a decision, a policy at the University of Montana, or the Montana University System rather, that prohibited gay employees from receiving insurance coverage for their same-sex domestic partners. And the Supreme Court held that this was sex discrimination. And that is true, absolutely. It was an important outcome. And the Supreme Court was able to make that decision because unmarried couples could, heterosexual unmarried couples could have coverage, but the insurance coverage for same-sex domestic partners was not permitted. So it was a good outcome, but what it really didn't do was address why the law was so harmful, right? The dignity aspect of same-sex couples being essentially, excluded from full coverage under the insurance policy. There are some federal courts that have specifically interpreted transgender discrimination to be sex discrimination, and they have done it under the theory that that discrimination against transgender people amounts to sex stereotyping, which has been found under federal law to be sex discrimination. And so the idea is if you tell a transgender woman, for example, that she can't wear makeup or dresses, then you're basically forcing her to fulfill a certain stereotype about how she should appear. And so transgender discrimination has been recognized as discrimination because of sex in the 9th, 6th, and 11th Circuits, and also by the Equal Employment and Opportunity Commission. And again, I think that's correct, but it doesn't go far enough. And the problem is that sex stereotyping can go both ways, right? So the famous, notorious RBG, Ruth Bader Ginsburg, famously relied on a strategy in part as she was developing the theory of sex discrimination under the U.S. Constitution. She relied in part on a strategy of bringing cases in which men were suing for sex discrimination, for example, not being able to be admitted to a nursing school or something like that, right? Or there was a case about near beer where females were allowed to drink it at a younger age than males, right? And so the problem, I think, with just a straight sex stereotyping analysis is that it doesn't really get at the unique harms that happen when a marginalized population, a specific class of people, is being discriminated against in a way that means to exclude them from full participation in society. There is something about that that is really an affront to dignity in a way that mere sex stereotyping doesn't capture, because that could be true of groups in the dominant group as well, right? So we wouldn't say that, even though we might all agree that a law discriminated against men, it really isn't fair to say that men are generally excluded from full participation in society in the way that women have for hundreds of years, right, in this country. So, so I think that is the promise of the Dignity Clause, is to be able to bring those things together. The U.S. Supreme Court, in Brown versus Board of Education, seemed poised to make more of a link between dignity and equal protection in talking about the stigma of separating black kids from other kids, right? And saying, and basically understanding that separate but equal doesn't make any sense, because even if the facilities were completely equal, which of course they weren't, but even if they had been, that there was still an affront to the dignity of black children in being told that they had to be in a separate space, right? Everybody knew that the reason that black children were being put in a separate space is because they were seen as socially inferior, and that was an affront to their dignity. That, however, that link between dignity and equal protection didn't last very long. So when the court decided Loving versus Virginia, in which the court struck down an anti-miscegenation law, right, that prevented white people from being, what it basically did was prevent white people from being able to marry anybody who was not white. And so the couple in that case, who were the plaintiffs, Mildred and Richard Loving, so aptly named, the court basically found that the law discriminated against, was an unconstitutional, race discriminated against on the basis of race in violation of the Constitution and the Equal Protection Clause, but it really didn't see the discrimination against Mildred Loving, who was black, as really any different from the discrimination against Richard Loving, who was white. But of course, it was Mildred's blackness that was what prevented them from being able to marry, right? That is why the anti-miscegenation law in Virginia was clearly premised on white supremacy and wanting white people not to marry anyone who was non-white. And so the symbolism that had for Mildred's dignity was just something not captured by, of course it was painful for Richard Loving, but it wasn't an affront to his dignity as a person, as a white person, in the way that it was to Mildred as a black person. So that case marked a kind of shift in which the Supreme Court looked much more narrowly and superficially at classes. And in the same way that I mentioned about the sex discrimination cases, right? Once you say, well, it's just discrimination based on a class, race, or a class, sex, then it becomes easy for the court to flip that around and apply it to either side of the classification, including the class that normally isn't regularly subject to discrimination, and certainly hasn't been barred from full participation in the society in the way that black women have, black people have, and women have, and transgender and non-binary people have, right? So I think that that is a promise that exists in the Montana Constitution in having our Equal Protection Clause be nestled within the umbrella of this broader provision on dignity. I just want to briefly mention, so I think one of the concerns about this idea of dignity is it's such a broad term and it can mean so many different things, right? So how are courts supposed to be able to interpret what dignity actually means? And I think Justice Nelson and Tom Huff and Matthew Clifford have done a good job of trying to elaborate that and showing that there actually are shared concepts of dignity that a court could apply. Another article that I have found extremely helpful is one by Naomi Rao, who wrote kind of presented a taxonomy of dignity in American law. And I'm just going to mention two of the three kind of concepts of dignity that I think are most relevant here. The first one is inherent dignity, which everyone has, right? This is just the idea that every person, by virtue of their humanity, has dignity that's not dependent on intelligence, morality, social status, right? Every single person has dignity, which is why we accord due process or the right to free speech, right, to people regardless of other external factors. A second concept of dignity is the concept of dignity as recognition, is what she calls it. And that idea is rooted in a conception of the self that is constituted, in part at least, by the broader community, so that a person's identity and worth depends on this relationship to society. And it requires that individuals demonstrate respect and concern for each other. And it can be lost if people don't recognize a person, right? Don't see them as full participants in society. And I think this third one is the one that is really relevant when we're talking about discrimination against transgender people and other marginalized groups, and is why discrimination against them should receive a higher level of scrutiny. Because it really is, discrimination against these historically oppressed and marginalized groups really amounts to an effort to remove these people from full participation in society, this particular class of people, in a way that denies them this recognition that's so important. And this is why I think it would be so wonderful if the Montana Supreme Court were to look at discrimination against marginalized groups, including transgender and non-binary people, but also other members of marginalized groups. When that discrimination takes the form of something like bathroom panic legislation, where it's attempting to exclude people from full participation in public life, that the court recognize that this is an assault on the dignity of people within that class, and that it merits stricter scrutiny when that kind of legislation is attempted to be enacted, or when that kind of discrimination occurs in the private sector.
Thank you, Caitlin. We now have we see some students or have to go to class and they're leaving, not because they're not interested in what we're going to continue to talk about for the next half hour, but they have other responsibilities. Those are perceptive concepts and thoughts from each of you. To give us all, I think, for thought. I've got a question that I could start out with, unless someone else wants to jump ahead. I see someone who might be a student.
I think I'm the only law student that doesn't have class at all.
All right, let's hear from you.
So I identify as two-spirit. I'm a bisexual indigenous woman. And something that kind of caught my eye in Article 4 was when it talks about culture. So I'm currently trying to get or draft a letter of support for House Bill 465. And
could you explain what that bill provides?
Yes, 465. It's going to hopefully have inclusive language for sexual orientation and gender identity. And someone tell me if I need to expand on.
Do you want that?
Yes.
Yes. Thank you.
Houston. Frank's little fried property midterm coming up. So the first thing I saw when I saw that, though, is I feel like inherently denying protections for sexual orientation and gender identity kind of could go against the cultural aspect of Section 4, because in Montana, certain tribes, I don't know about all of them, my tribe is not from Montana, but we never had a problem with sexual orientation, and we never had a problem with gender expression and gender identity. For us, it's always been a cultural norm, third, fourth, fifth, and sixth genders, to the fact where not only were they recognized, but they had celebratory, like we celebrated that, and they had very specific roles within the community. So I just feel like inherently denying someone the opportunity to, I'm just going to say, fully function in society in Montana, sort of just kind of goes against beyond this language that's inclusive of culture. And, you know, I didn't even apply to clerk anywhere this summer in Montana because I was afraid if I dressed like this, that, you know, I would be asked to leave. And so reading this just kind of thought, you know, maybe I should have pushed on that a little bit. Maybe I should have kind of tried to embrace the spirit maybe behind the use of culture. So, I'm rambling. I'm going to turn it back over to the experts.
Who would like to take a stab at that comment and question?
Well, I'll just, you know, further frame that if we think it in context, particularly with respect to, we see culture appear in another place in the Constitution, and that's with respect to our collective duty to preserve the integrity, the cultural integrity of Native Americans. And so actually, that's not, that is a connection that the framers themselves made in terms of thinking about culture. I think they have that in part in mind, and where it goes from there and how you can connect that more broadly. I'll leave to the others, but it's worth, the Montana Constitution itself makes the connection you've made.
Anyone else? Thank you. I'll exercise the prerogative. Oh, hey.
I had a question for Professor Johnstone about your use of the word premise. My problem with it is premise implies that it's not inviolable, perhaps. Could be true, could be not. It's just the starting point. And so, would you help me through that?
Yeah, part of that might be an artifact of me coming up with that framework to explain it about a half a minute before I started talking. So premise may not be the right word, but it is the underlying truth. But it should be it could and should be distinguished from a standalone right. I think, in other words, what I'm trying to do is give a word for the one conception of Section 4 in which the dignity of the human being is inviolable is the reason for the rights that follow, but is not necessarily a what we would call either at least a self-executing justiciable right on its own. So that's all I meant. It's true. Everyone knows it's true. The framers knew it was true. It's a reminder to all of us that it's true. But whether it's true or not, truth is not enough to. That's not the same as law, as binding law. And of course we see language like this throughout this Constitution and other constitutions, and it can be puzzling if you don't understand the natural rights tradition against which it's drawn. So maybe premise is the wrong word, though. I appreciate that.
So I'd like to ask Justice Nelson if he would comment on the distinction that Anthony has drawn between a premise and an express right.
Well, I guess, and I certainly respect Professor Johnstone's views. As an aside, co-taught Montana constitutional law with him in 2013, And I dare say I learned a lot more than I taught the students from him, so I mutual respect his I guess, John, I have to go back to my conception of what human dignity is. And to me, dignity is just the essence of being human. It's the uniqueness of each individual on the face of this planet. It's the fact that each of those people, each of the 7 billion people on the face of the earth, uniquely have an inherent and value that's just theirs. And I don't think any government or law on the face of the earth is entitled to take that away from someone. I recognize Professor Johnstone's examples. Sure, we incarcerate them, and we have to incarcerate people that violate the laws or are a danger to society. But there isn't any reason that we can't incarcerate people and still respect their dignity as human beings. We got into that a little bit in Walker, where you had a mentally ill inmate at Deer Lodge who was acting out constantly because he didn't have his medication that he was supposed to have, and he was thrown in a cement cell, literally. No clothes, no bedding. He was thrown in a cement cell, fed meals through a slot in the door that had feces on it. When he knocked out, the troops had come in and hosed him down with a fire hose. That is not respecting a person's inherent self-worth. This man had self-worth. He was mentally ill, but he still had worth. And I mentioned this example in my Baxter concurrence. We all, I think, probably in this room, remember Abu Ghraib and the pyramid of naked prisoners surrounded by dogs and troops with guns. And it's just repelling to look at that. And I think we're repelled because we recognize that each of those people in that human pyramid, or naked human pyramid, each of those people, just like us, has a unique sense of self-worth, has a unique value to society. We may not know what it is, but we all recognize if we have it, and I think we all think we do, then our fellow citizens have it. So that's why I think that dignity is a standalone right. I think it's the most probably basic fundamental right that's articulated in the Constitution. And I agree with Caitlin, and I agree with Professor Johnstone that this unique right needs to inform other rights. It needs to do more work than it's doing, and the courts aren't using it, and that's very frustrating to me. I left the court. Anthony's right. There haven't been any more cases brought involving dignity. There should be. There should be. Certainly in discrimination cases, in God knows, all we have to do is look at what's happening in the federal government. The whole tone of this country has changed, and I'm not picking on our fearless leader, but the whole tone of this country has changed since 2016. It's changed toward more racism, more violence, more diminution of marginalizing people on the border, taking people's children away, putting people in cages. That doesn't recognize dignity. And to me, it's very troubling, and I agree with the other panelists. I think it needs to do more work, but in my view, it's not a premise or an aspirational value. I think it's a real substantial right that we as a society have to respect. And God knows if we did, I don't think we'd be seeing the kind of dissension, the kind of government, the kind of what's going on in the society today.
Thank you. Justice Nelson and I would note for the record that it took about 30 years before you, in the Walker decision, and our Supreme Court first decided to use the dignity provision to augment the right in Section 22, the prohibition against cruel and unusual punishment. And one of the things that we were kind of shocked by in my class was thinking, my goodness, it certainly does take a long time to get new law to be made judicially in our system of justice. So the glacial pace of reform is something that I think we had to have in the back of our minds. Secondly, I would note that that you did step beyond Article 4 in the Walker case to use the dignity clause to strengthen the prohibition against cruel and unusual punishment. And I understand where Professor Johnstone is coming from when he says there's a lot more work that can be done just within Section 4, where the relationship between the Human Dignity Clause is much more closely related to anti-discrimination and equal protection.
Well, let me use another example. And courts frequently combine two constitutional rights to achieve a result. The Montana Constitution protects the right of free speech and freedom of the press. And Montana's Constitution also protects the public's right to know, Article 2, Section 9. And frequently, we use those two rights together. Freedom of the press cannot bear the weight that it must do in our society in Montana without combining it sometimes with the right of the public to know. The press has the right to go into to a public office and get public documents and get copies of those public documents and report on those. And I'm involved in a case that I'm not going to get into at all right now, but it's a case in which this right of free press, the right of the public to know, is being violated constantly on a daily basis by the county commissioners in one county of the state. And it's absolutely incredible. That's a perfect example of where we take two rights together to achieve a result.
I think.
So,
Thank you.
The way I see this framing up is that Professor Johnstone is saying, I read this language, the dignity of the human being is inviolable, and I don't see the word shall or shall not in there. And so the word that you used was, does this create a justiciable right? And the question is, or the answer to that question is, I don't know. It's not clear. And I hear Justice Nelson saying, well, it damn well should. And the justiciable right issue then frames up the question, can those words command you shall or shall not do something that is enforceable? In other words, can we go to court and force someone to respect human dignity based upon that language alone? And that always works out to an end game discussion is, well, if we permit that, will all hell break loose? And that's, as a practical matter, what the question is. And I'd like to hear all three panelists discuss what would be the practical ramifications if Justice Nelson got his way and it was a justiciable right to human dignity. How does that play out? As a practical matter, why should we embrace that or fear it?
That's an excellent question. Who'd like to take it first?
You're the one who's likely to do it, if anyone, right?
It's a great question. I mean, the courts would have to come up with some kind of parameters. I think that the examples that Anthony has on here of like the laser tag decision in Germany, right? I mean, presumably that doesn't seem like it would be a likely decision that we would see under the dignity clause under a dignity clause anywhere in the United States, including Montana. So again, I mean, I'm just going to punt to Naomi Rao, but I think that her taxonomy of dignity is really helpful because I think that it is such a murky term, or it's such a broad and flexible term that it can be used in so many different ways, and if you don't parse it out, then it could be subject to widely differing interpretations by courts, which is always, you know, is potentially problematic. So, for example, in Obergefell, I think, and this was on the decision in which the Supreme Court held unconstitutional bans on same-sex marriage, the court talks about dignity in the sort of, in a couple of different senses, I think, but one that's notable is sort of this inherent concept of dignity, because they say, you know, you can't, dignity is not something that can be taken away, right? It's like people have dignity, and it can neither be bestowed nor taken away. I might have the wrong decision, but I think that's the one.
That's Justice Thomas's dissent.
Okay. Well, so that is an inherent concept of dignity, right? And whereas the one I was talking about is a concept of dignity as recognition, I think each of those are concepts that could be used in American law and wouldn't be foreign concepts at all, but they would actually be helpful in certain instances, like the example I gave of equal protection, where we're just not quite getting at what I think the crux of the issue is by just talking about sex stereotyping or sex classifications, without getting to the dignity aspect of it.
Well, John, if I could jump in, in fact, I think to answer Randy's question, I think not all hell would not break loose. That we hear that constantly in courts. You know, the slippery slope and the sky is falling. And I've never seen it happen in my 20 plus years as a judge and retired judge. But I think, Caitlin, that the transgender issue would be a perfect issue to litigate on the concept of dignity. I worked with ACLU in we never got to court, but in a case involving the bathroom bill that the Family Foundation was promoting as an initiative that was supposed to be on the ballot this time. It was defeated largely because he couldn't get enough votes to get it on the ballot. But we, as a prophylactic measure, working with the ACLU, developed a legal strategy for dealing with that if it did get to the ballot. And the thing that struck me in that whole process of talking and listening to, reading about the statements from transgender plaintiffs and transgender people and students who were transgender, older people who were transgender, was the concept that imagine being born with one set of genitals, and that's what's on your birth certificate, and at the same time knowing inherently, intrinsically, in my soul of souls, I know that I am the other sex. And to me, that is human dignity defined right there. My self-respect, my sense of worth, my inherent, intrinsic sense of who I am. And in my view, the Montana Constitution protects that concept. And believe me, if that were litigated in the court, I'd be jumping all over the right of dignity on that issue. Because to me, that is the essence of human dignity right there. And I hope it comes before the court. I think that's what it's all about. Transgender people are demonized, they're marginalized, they're made out to be something that they're not. They're our fellow citizens, our neighbors. They're fellow human beings. And they have a right to be treated with the same sense of self-esteem and self-worth that we would want for ourselves. And that's the essence, in my view, of dignity. And that's why I think the standalone right, I think it should be the subject of some litigation.
Professor Johnstone, do you want to weigh in on this?
Yeah, I mean, I think Randy asks one of the key questions here, and I agree with Justice Nelson. I'm not sure that I see a parade of horribles following from a recognition of a standalone right of dignity, whether it's a matter of recognition or inherent, because of course we see justices on the Supreme Court, U.S. Supreme Court more recently, deploying that idea all sorts of places. But of course it's not it's not an indeterminate idea. I mean, we all know that it's an idea about autonomy and worth, self-worth, but it is underdetermined. We see that in Baxter, where both Justice Rice in dissent and Justice Nelson in concurrence are drawing on the concept of dignity, different conceptions of that idea. So I think probably what happens if it is recognized as a standalone right is that lawyers and law students have some homework to do, and law professors to try to give that some additional definition beyond. And when we say standalone right, I'm saying that a right that does work not in a hybrid way, as it would in Caitlin's account of amplifying the equal protection guarantees, or maybe in Walker. And I think Walker is the toughest case for anyone who doesn't think that it's a standalone right, because Walker dealt with this awful degradation of a prisoner, which frankly is not cognizable as a matter of federal constitutional law as cruel and unusual punishment, because it's not necessarily viewed as punishment. So what does the federal Constitution do? They look at substantive due process and liberty, which isn't anymore, that shocks the conscience and those sorts of things. So it is nice to think that dignity might be a kind of safety net to keep us behaving humanely to each other. And if it served that purpose, I think, I'm not sure that you see a lot that follows. I think one thing that would happen is in the most contested cases, the cases where Montanans are most divided on these issues, you will see Montanans, advocates, and judges try to fill in their own content of that. And they will do that through judicial elections, and they will do that through constitutional amendments, both of which give the people emphatically the last word in Montana. And that's one reason that I think currently might explain why courts are cautious, not as risky as Justice Nelson, not as bold as Justice Nelson has been with this area, is because the people have the last word. If we can't give a satisfactory consensus meaning of dignity in the way that we might have more consensus around ideas like non-discrimination, the people will figure out how to fill those blanks themselves, and they'll do it through ways that might be disruptive and maybe do not permanent, but certainly some lasting harm to our idea of a shared constitution.
Thank you. I think we've got time for one more quick question.
This gentleman. John, I was going to offer before Randy's comment, which was apt, I think, his question, it's going to add a bit of historical context. When I argued the Baxter case to the Montana Supreme Court, there were a number of pointed questions in response to my presentation. One of them was from Justice Morris. And if I remember this correctly, this is 10 years ago, the thing he asked me was, he said, well, if you and Judge McCarter in the lower court are relying at least in part on human dignity, how do you define it, and can you, he said something to the effect of, how can you define it in a way that's not going to open this huge box that people are going to want to throw cases in? And I don't know I gave him a very good answer, but I acknowledged his leading me into the point that this is going to be determined on a case-by-case basis. Obviously, I think the perspective everybody had, and I think the limited jurisprudence at that point was the effect that human dignity will apply in the most egregious circumstances. The question was this one of them? I certainly thought it was. And so I referred him back to the Armstrong case, and Justice Nelson's wonderful description of that, that it had to be a fundamental question about the meaning and value of people's own lives and intrinsic value of life itself. And I thought that applied in this case. The other thing I was just going to add is, when people tried to argue that there is not a standalone right of human dignity, a lot of people at that time, 10 years ago, were arguing the point that the reason dignity is used in Article 4, in Section 4, is simply to categorize the individual rights that follow in the next sentence. So whether you call it a premise or a categorization, they said it didn't have any standalone meaning, which we obviously disagreed with, and the Armstrong and the Walker cases didn't support, but that was what people were arguing at the time.
I should just mention, Mark and I are at work right now on so Baxter, it'll be 10 years. It's 10 years this year since the Baxter decision was issued, and September 6th, I think, which is a Friday, the law school, along with Compassion and Choices, so we're getting the band back together in terms of the lawyers on opposite sides, along with Justice Nelson will be hosting a day-long symposium involving lawyers, policymakers, Justice Nelson, and other advocates and clinicians in this area to look at Baxter 10 years on. So look for that. That'll be September, whatever that Friday is. I think it's September 6th, right?
Yeah.
September 6th here at the law school this fall.
Thank you for reminding us of that date. That's something to look forward to as we continue this discussion, which has raised a lot of questions and has illuminated different approaches to the questions, but I'm not sure that we have yet the definitive answers. So we shall continue to think about this. With that, I want to thank our panelists, Justice Nelson, Anthony Johnstone, Caitlin Borgman. Thank you so much for participating.